My name's Alex Haile. I'm a domestic attorney in our Winston-Salem office. A domestic violence protective order, or a 50B or a 50C, is an order where one party would go to the court ex parte, which means without the other party present, and they would essentially plead their case to the court to explain to the court why they are substantially frightened or feel harassed by an opposing party. A 50B is appropriate when the parties are former spouses or have lived in the same household. A 50C is appropriate when they haven't lived in the same household. When we're talking about 50Bs, it's usually spouses or maybe a mother and a child or a father and a child. When we're talking about 50Cs, it could be a grandparent and a son-in-law or something like that where they've never lived in the same house, or it could be two people that work together who don't like each other anymore and have had some sort of incident that required one party to go to the court to seek this protective order. When they receive this protective order, again, it is ex parte, so they're going to the judge without the other party present, and the judge pretty much is going to have to believe whatever they tell them. If that judge finds that that party has a subjective fear of that other person or any other reason that the 50B would be warranted, then they will grant that ex parte order. When the ex parte order is granted, it requires the party that the order is granted against to have zero contact with the other person. That means no phone calls, no text messages, no Facebook messages, nothing. Most importantly, and where many people do get in trouble, is they'll try and have contact with that other party through a third party. That also is prohibited, so they need to make sure that they don't do that as well. A 50B is a civil order, it's not anything criminal. However, if you violate a 50B, then it becomes criminal and you can be held in jail. After the ex parte order is entered into, in order to have due process for that order, the parties are required to go back to court in about 10 days to have a return hearing on that order. At the return hearing, that's when the other party gets to put on evidence to show why they believe that this ex parte order should not have been granted, why they believe that that other person is not frightened of them. They may put on evidence of text messages to try and discredit what the opposing party has said about them, and that's also the party who took out the 50B. In order to get a 50B or a 50C domestic violence protective order, the party that's seeking the protective order is first required to file a complaint. Within that complaint, they need to put enough evidence as to why they are frightened of that other party or why they believe that the domestic violence protective order is necessary. Within that complaint, they will file that with the courthouse, and then typically within that same day or the following afternoon, they will have a conversation with the judge, which is their time to essentially back up what they've put in that complaint. At that time, the judge will listen to them, they will read their complaint, they will read through everything, and they will determine whether or not they believe, based on the pleadings, so the four corners of that document, and what that person is saying to support that information, whether or not they find the protective order is warranted. At the hearing is when parties are really putting on evidence as far as text messages or maybe videos or other information that the court will find whether or not that ex parte order should really stay in effect or be dismissed.